There we go. So we are now recording. So welcome everybody. As you come in, please remember to put yourself on mute and off screen. That will help with our connectivity and our bandwidth. My name is Dan Lindsay. I'm glad to welcome you back, hopefully, to what is the fourth session of 4 in our Bankruptcy Help Desk volunteer training series. And can somebody go on mute? It sounds like we're getting some background noise there. Just remember, if you're not Sal or Judge Cleary, to go ahead and put yourself on mute. Thank you. So this is the last, but certainly not least, of our series, and we're really excited because we have 2 presenters today, both of whom are superstars and experts. And Denny's putting some stuff on the chat, I think the links to help you get to the presentation, and then maybe a little later to the CLE stuff. And so this week we're doing post-confirmation issues, and Sal Lopez will be starting us off. And Sal is a private attorney in private practice doing bankruptcy cases, and has been doing so for a long time. And since I'm still at Legal Aid Chicago, I have to point out that Sal used to be at Legal Aid Chicago, so he's one of our beloved alums. And Sal's also one of our longtime, really great volunteers at the help desk. So he will have a lot of really helpful and useful and concrete information to share with us. And then I think later in the presentation, Judge David Cleary will take over. And we're very excited to have a member of the bar with us helping to do the presentation. And Judge Cleary was involved with the Bankruptcy Help Desk before he joined the bench, and has been obviously in private practice for many years, and a bankruptcy expert, and just joined the bench this past year. So we're really excited to have him. So with that, and no further ado, I'll turn it over to you guys. I think Sal's going to go first. Is that right?
Yeah, that's correct. Good afternoon, everyone. Thank you for joining us on this Thursday afternoon. Just a couple things before we begin. Both Judge Cleary and I are of the mindset that ask questions throughout. You can put them in the chat or take yourself off of mute. Saving it to the end, sometimes we tend to forget what you were asking, or something along those lines. So if you do have a question, feel free to ask throughout. Jadeni, if you see anything in the chat, please interrupt and let us know. I for one, I'll say that I'm glad that a former bankruptcy help desk volunteer has made it onto the bench, because although most of the judges, all of the judges actually, are very supportive, I think, of the help desk and the volunteer work that's done there, I think having a Judge Clear on the bench who actually understands from the perspective that we see is very helpful. So I'm thrilled with this partnership with the presentations that Legal Aid Chicago. I apologize. I keep messing up and saying LAF. I know it's Legal Aid Chicago now. But anyway, so we're going to discuss today post-confirmation issues in the Chapter 13, after a plan has been confirmed, what types of issues are seen at the help desk. I will say that I feel that this is probably the easiest part, because getting a Chapter 13 filed and actually confirmed is a very difficult thing to do. So if you're seeing a client come in with a already confirmed plan, I feel that most of the battle has already been won, and you're just helping clear up some final issues. So what are the types of, this is not a comprehensive list, but the most common, I'd say probably 90% of the stuff in the help desk is covered by this list, and in reality only by 3 and 4 of those things. Amending petition and schedules, plan modifications, incurring post-petition credit, conversion versus dismissal, what happens after you complete plans, and how does you get a discharge, what happens if if the debtor can't complete plans and requires a hardship discharge. After the discharge is received, someone comes in with a potential discharge violation, and in re mendiola, which some of you may not realize what that is, but we'll talk about it briefly. So
if I could just mention quickly, the reason I'm sitting on this panel primarily, although I would have gladly sit on any of them, because I think it's a wonderful activity to have this help desk going, is that so often the goal seems to be to get the plan confirmed, which obviously it is a huge goal. But the debtors who are very appreciative of all the help that you give them at the help desk, I think sometimes just go off without realizing that there could be many things that need to get addressed afterwards. And a good thing to do is just always remind them as they approach that final hearing when they think they might get confirmed or they do get confirmed. And even a couple meetings before that, when you see them at the help desk, remind them, always watch their mail, always be cognizant of things that might come up and come back to the help desk, and you can try to address it with them. And most importantly, make sure that if they get anything in the mail, they come back and address it with you. And before Sal goes on any further, I just wanted to also add that although Dan said there were two experts on this panel, I think we all know Sal is the real expert here. I, like several of you who are on this call, didn't primarily focus on Chapter 13s when I was in practice. I helped out on the help desk, which I found to be fascinating and rewarding, and I'm sure you all do too. But I was hesitant to get involved. I know there's some on here, I see names that have been now doing it for a long time and probably were in the same boat as I was when I first started doing it. For those of you who haven't done it yet, don't worry about not knowing what you're accustomed to if you're doing Chapter 11s or don't practice in the Chapter 13 area, because the help desk has a lot of resources. Dan and his crew are there as a backstop. The primary goal is to get the folks who come into the help desk going and understanding what they have to do, helping them out, and then you can certainly turn to the resources if you don't have the answer at the particular time that they walk in the door. So I just wanted to mention that before Sal got too far into the details, because I do think it's important to you all know that it is very much appreciated by all of us.
Thank you, Judge. And I'll just add, if you're thinking about it, do it. Legal Aid Chicago does a tremendous job of, as Judge Cleary said, providing you with backup. You're not left alone when you volunteer for the first time. Well, actually, before you volunteer for the first time, you shadow another usually longtime volunteer. Before it used to be in person, now it's over the phone. And I think we're working on eventually doing it via Zoom. And then once you shadow a few times, then you volunteer and you're shadowed by one of the longtime volunteers until you feel comfortable enough. And even when you're on your own, you're never really on your own, because you're given phone numbers and email addresses of people that can be there to answer questions if something unexpected comes up. And most of the time it won't. You'll start to see a pattern of the same types of questions at the help desk and start to feel comfortable. And there's also email exchanges that go back and forth between the volunteers sometimes when a complicated issue does come up. And there are some things that are too complicated for the help desk. And in those cases, we say, hey, call Legal Aid Chicago to see if they can find a referral for you, because this isn't something that we're going to be able to advise you through. So if you're thinking about it, definitely do it. As Judge Cleary said, it will be very rewarding. No matter how limited your experience is, Legal Aid Chicago does a tremendous job of providing you with the resources that you need in order to be able to help desk clients, both debtors and creditors that come in with questions. So with that being said, jump into the first section, amending petition and schedules. This does come up. It's pretty straightforward. Rule 1009 allows a debtor to amend petition and schedules as a matter of course. You do have to provide notice to any entity affected thereby. Most of the amendments may not affect the creditor, so usually just it gets notices, you email a copy of notice to the trustee. If it may affect a creditor, then to be on the safe side, I always advise a help desk debtor to say, hey, mail it to the creditors just to be on the safe side. But most of the time, the reality of it is it's not going to affect a creditor, especially if it's something that relates to an asset that gets fully exempt anyway. There is a $32 fee for amending schedules D, E, and F. That's because the court mails documents to creditors on D, E, and F, and D is, or now it's EF is one schedule, and D secured creditors, E and F is priority, and unsecured creditors. So as I know we're at the post-confirmation, but one of the maxims that I always say at the help desk is always advise potential clients that although they are allowed to file in two parts, filing the emergency bare bones petition to start the bankruptcy, and then they're given 14 days to file the rest. People always confuse that to think, oh, I can file my case today and then I'll deal with the details later. And it's simple. It's not. In my experience, a lot of debtors who do that have a really hard time following up and wind up with dismissed cases. The next thing you know is 2 or 3 cases. So unless there is an emergency that truly exists, a foreclosure sale, repossessed car, a suspended license, utility that's shut off, I always advise debtors to not file in 2 parts, to combine it. And there's always this as well, because any changes may cost them money with regards to creditors.
And not only for, like you said, Saul, not only for this post-confirmation period that we're speaking about, but with everything, keep a copy, but most particularly with post-confirmation, quite often things will get filed, and obviously the other parties, including the Chapter 13 trustee, has a lot going on if they show up for a hearing, and the question is, well, I told them that because I put it in my amended I and J. If you don't have the I and J with you, it might just take a little time. It might just take another continuance. So advising the debtor always to keep a copy for themselves to have with them is very good advice. I'll also take a moment, just as long as we're on sort of a general filing topic right now. As you all probably all aware, the clerk's office has been opening and closing over the last year, depending on what the situation is with COVID. At the present moment, they're closed. But for pro se debtors, you should advise them that not only can they file things by mail, or also there's a drop box, but now there is an ability to have them, pro se debtors, file things electronically. And not only file the documents electronically, but there's also a portal that they can make payments rather than just necessarily sending in a cashier's check by mail. They can make certain payments to the clerk's office on an electronic portal. So that's very useful. It's all posted on the court's website, although not in the same place. You have to piece it together, but you'd be able to find it.
Yeah, that's great. I'm actually thrilled that the electronic filing is open for debtors, because that create, especially with during COVID, it created a lot of issues. So I think it'll just make things easier. So some of the common amendments that you see on the petition, I'll explain it like this. When someone says, I don't want to file bankruptcy on my car, I just want to file bankruptcy on this debt. That's not the way it works. You file bankruptcy yourself, you declare bankruptcy, and then there's a specific set of parameters and rules that you have to follow about what's allowed and what's not. So just remember to remind debtors that everything has to be listed. You have to be an open book when you file bankruptcy. You have to list all your assets, income, debts. So a lot of times they'll say, oh, you know what, I didn't, I forgot to add my car, or I'm getting my tax return and the trustee says that they want me to turn it over because I didn't list it. As long as it's exemptable, I mean, if it's over $4,000, then they're probably not going to be able to exempt all of it. But in a Chapter 13, as many of you saw in the presentation last week with Yannick, who did an amazing job, it's just recommended in the Chapter 13, just prorate the amount of the tax return into the plan, so then it's not an issue. Missed exemptions, if they list something that they want, I always say, if you list something in A and B, A is real estate and B is personal property, you also have to list it in C if you want to keep it. Not, you don't have to say chair, table. It could be, household furniture. If household furniture is listed on B, it also has to be listed on C if you intend to keep it. Adding missing creditors, as we said, DEF, it comes with a $32 fee, or correcting discrepancies in I and J, income and expenses. Procedures for amending the schedules. You can't just, a debtor will just want to make the change on the already filed schedule. You can't, if the draft a new one and check the box saying that it's amended, and go ahead and file that, and then provide notice at the very least to the trustee. So plan modifications, a lot more common than amendments to the petition and schedules. So first things first, you always, and it's great when a debtor brings in a copy or has a copy of the paper plan that's sent to Janetti, because it's not in person now. But if not, one of the things that Legal Aid Chicago will provide you with is an access to an account with Pacer, where you can view all documents for free. So you don't have to worry about actually pulling up documents and paying the 10 cents per page. There is an account that Legal Aid Chicago has that will give you access to all those documents. So the very first thing you should do, and right now with everything being virtual, it's a lot easier to volunteer, because you'll actually get Jadeni, the bankruptcy help desk paralegal, will send you a summary of the issue that the debtor's having and the questions that they have ahead of time. So you can actually prepare. You can do your research ahead of time so that you're not kind of put on the spot trying to figure at the help desk. One of the most, at the very beginning, when you first start volunteering, one of the most intimidating things is having the debtor talking to you on this side, trying to explain everything to you while you're trying to pull up their documents. Right now that's gone because you get everything, you get to cheat, you get everything ahead of time. So you can do your research and be ready to chat about the actual substance of the case instead of trying to figure out what's going on. The very first thing you should do when there's already a confirmed plan they're trying to get the modification is look at the plan. The court has already made a determination that and the trustee that the plan was feasible, and that it was, for that reason, it was confirmed. Now you have to figure out why the debtor wants to change it, but you should always start with the confirmed plan to know what you're starting with. Then ask yourself, what is the debtor attempting to modify? Amend plan payment, change the term of the plan, reduce percentage to GUC means general unsecured creditors. There's a list of priority secured creditors, priority creditors, and general unsecured non-priority creditors. Defer a default, that just means that they've fallen behind for whatever reason. They were laid off of work for 2 weeks because they had surgery, but they're back at work now, and they just want to take the amount that they're currently behind and put it at the end of the plan. Run the numbers next. Once you figure out what they want to do, what they're trying to accomplish, actually run a calculation to see if the plan is feasible. Feasible just means, hey, if they're supposed to pay $8,000 to a secured creditor at 6% interest at the till rate, and then there's supposed to be another $2,000 left over at the end for the unsecured creditors, but the change that they're trying to make actually only pays $6,000 into the plan's not going to be feasible because the secured creditor has to be paid in full and there has to be something left over for the unsecured creditors. So just run the numbers to kind of give an idea, and you know, it has to fit.
Well, and that goes to your point. I think it's number 4, Sal, and it's a great point. And what it means specifically is if you look at 1329, they're the enumerated bases under which you can move the court for the amendment. But when you do make that modification, it still does have to conform to some other sections of the confirmation standards that were previously approved and still have to be applicable and approved going forward. So your point's very good and something that people often don't think about, and they should, because sometimes the strategy might not require or it might not be available at this particular time. If there's not a pending motion to dismiss and the debtor is not employed at the time, not receiving unemployment, has no income, and therefore can't fund the plan, why try to, one may argue, why try to file a motion to modify that can't satisfy the statutory requirements of the plan, and yet there's no motion to dismiss pending? Think about it, strategize about it. You know, it's just not always a knee-jerk reaction is the point, because as your number 4 says, it does need to meet the other requirements of the code.
Correct. Though bankruptcy is an incredibly powerful tool, it's not unlimited, and there are limitations that have to be kept in mind. That sometimes there's just situations where I tell a help desk client, bankruptcy is not going to provide your solution. You have a problem, but bankruptcy is not the solution. Moving on from that, 1329C also says that the judge just has no discretion to increase the term of the plan past 5 years, with one exception that we'll talk about here in a second. So common reasons that you see at the help desk: adjusting plan payments due to change circumstances, usually a reduction in hours. I changed jobs that I'm making less now. Strangely enough, we don't see the I'm making more money and want to increase my plan payment, but I guess that technically can happen as well. Adding an additional creditor, especially a priority creditor. Sometimes if a plan is confirmed at the first confirmation hearing, especially with the longer deadline for government creditors to file a proof of claim, the IRS or Illinois Department of Revenue may come in with a claim for priority that has to be paid, that the debtor either didn't account for at all or didn't, was short. May have thought that it was 3,000, but it was actually 8,000. So that will require a plan modification. Or as we said, deferring a default when adjusting a payment amount is not feasible. Most common example is the debtor's paying $100 a month, and that's all that they can afford. They've fallen behind 3 payments because they were laid off, but they're back at work now, and they're 2 years into the plan on a 5-year plan. Just defer it to the end, where you tell them, hey, you are going to have to pay this by the end, so we'll defer it. And the trustee, if it's a small enough amount, the trustee won't object. It just, you're going to have to find $10-$20 here and there to catch up towards the end, because the full amount will have to be paid. It's not going to be forgiven.
And going back to that last slide, think about practically again, what you're asking for and what you need to get that approval. And what I'm speaking about specifically is you may very well have a valid basis. It's a no-brainer perhaps, but still you have to prove it. You have to sort of show either the judge and also any of the other parties, particularly in this case, the Chapter 13 trustee, why it's justified. And so often what happens is there's a valid reason, but there's nothing supporting it other than the bare bones motion. I advocate for a lot of these, at least, think about what your evidence would need to be. And if you can cut that off, going into the motion, you're going to save a continuance, you're going to save an objection by the Chapter 13 trustee. If you lost your job, you had a default, now you've got a new job and it's at a lower amount, attach an affidavit. You've got the pro se debtor there in the office at that time. Maybe you can knock out an affidavit, attach that. Maybe you can knock out an amended INJ, attach that at the same time, and therefore you might, avoid the objection, avoid anything, and it might even get granted without hearing. So, think about what your possibilities are, going into these, rather than just always filing the motion without thought.
Yeah, and at that point, one of the things that you can also advise debtors is communication with the trustee's office. It's not easy, but at the very least, at the court date, they can wait until they can call in advance, or wait during the time period and ask the trustee virtually before it's to be in person. Or the trustee will just say, when the case is called up, what issue they have with it, tell the debtor to listen to what the trustee is asking for and write it down, so they can come back to the help desk at that point to if they can't figure it out, to provide whatever is missing, or additional documentation or evidence may be needed. So I said there was one exception. Under the CARES Act, any plans that were confirmed prior to the passage of the CARES Act can be extended up to 7 years if there's a COVID, due to COVID. So if someone, it's specifically meant to address people who maybe were laid off or had lower payment because of lower income because of unemployment for some time, they have this ability to extend the plan up to 7 years. There isn't a lot of guidance so far, because this is relatively new as far as case law, but I mean, it seems to be pretty straightforward that if someone qualifies time-wise, they should be, and that is temporary. I believe there is a sunset, but I don't remember what that is at this point. But if you do have someone who had their plan confirmed and they're having difficulty and they need to complete the plan because of a cram down on a secured debt or something along those lines, then just consider an extension past the 7 years if they qualify.
Yeah, not only is there a sunset, which I believe is approaching sometime this year, but the counter problem that we're starting to see is that because COVID has gone on so long now, probably a lot longer than the folks who wrote this legislation thought, is you're starting to get debtors in a position that their plans were unfortunately confirmed while things were still relatively okay in March, April, May of last year, but now they're running into problems, and they're not eligible for this 7-year relief. So they're going to have to go in under the normal 60-month maximum at this point in time. I don't know if that's going to be extended. The whole bill will be extended. The 7 years will be extended or not. But we'll see.
So the procedure to file an amendment to plan, you do have to provide 21 days notice to impacted parties. Most of the time, an amendment to the plan, there's an argument that can be made, will affect all the creditors, unless you're leaving the exact same, they're receiving the exact same amount of funds and percentage, in which case the 21 days wouldn't be necessary. But in most cases, for help desk clients that come in, there's going to be some change that impacts the creditors. So they're going to have to provide notice to all of the creditors. And under local rule, any plan that is filed not with a petition, an amendment, or a modification, notice has to be sent. And the debtor also has to file a the notice with the court showing that they mailed a copy of the plan to the creditors. So you pick a hearing date, something super simple, but we often forget the debtors may not understand that they can't just pick a day, that it has to be a date and time that the judge hears these types of motions. All of that information is on the Bankruptcy Court for the Northern District of Illinois website. You go to the particular judge's page and click their motion calendar. And there's also a list at the top that tells you on any potential dates that judge may not be sitting. So you just want to make sure that it's not one of those dates. There is the form notice that's required right now due to COVID with the language on how to join Zoom. Jadeni is a great resource for sending. You can tell her, ask her to please send that document to that particular client after you explain to them what it is. That way you're not trying to find it, download it, and email it to them when Jadeni already has this, and just shoot it to them quickly. Every motion that's filed requires a proposed order as well. And it's simple. What are you asking for? Put it in the order. Whatever you're asking for in the motion, put it in the order as a proposed order and file it so that the judge, when they enter the order, has something to work off of. They may amend it or make changes to it as necessary, but you do have to file a proposed order. I always inform the debtors this. I tell the story that nothing would kind of make my skin curl up more than when we were live in court and I would hear a debtor say something and they say that they were told at the help desk, and just it was difficult. So, but Judge Cleary clarified that they understand that sometimes debtors, it is a little bit complicated. Sometimes debtors don't understand completely or misunderstand. So the judges understand that they weren't advised improperly. But what I do tell the debtor is practice this. We sort of have, as a society, in our society, attorneys have sort of been prejudiced by Joes like Judge Judy and Judge Joe Brown, where everybody thinks that they're going to step up in front of the judge and have 30 minutes to argue what they're asking for. As we understand, that's not the case. I always tell debtors, have in writing what you are going to ask the judge for. Practice it as short, as concise as possible, maybe 30 seconds at most, because you will not be given a lot of time to present it. And the judge hears hundreds of cases a day sometimes, so they're not going to remember you or your file. You have to be ready to provide a little bit of background on what it is you're asking for in a very concise time period. So that's, I think, one of the best pieces of advice that we can give to the debtors to kind of help them understand the process and represent themselves well. Rule 9014 does treat a modification or objection to a modification of the plan as a contested motion, so those rules are in play. So I will say, most of the time, if you can get the trustee, the Chapter 13 trustee, to agree, I tell debtors, to your proposed modification, that's more than half of the battle, as long as no creditor shows up. And rarely do creditors, unless it's impact the creditor like a secured car or maybe the city of Chicago, if it's parking tickets, something along those lines. But if you can get the Chapter 13 trustee to agree or to not object to your proposed modification, that's half the battle. And assuming that everything else is in play and you provided all documents necessary, then the judge is likely to grant your requested modification. So incurring post-petition credit doesn't come up super often, but it does come up every once in a while. What does that mean? Anybody who's in a Chapter 13 can't just go and apply for a new loan or refinance their car or a house. They do need court permission. Section 364 and Rule 4001C are the ones that are in play. The most common that you'll see is, hey, my car broke down. They're telling me it's going to be $6,000 to fix the transmission, so I need a replacement vehicle because I need to get back and forth to work. That's probably the most common. Every once in a while, you do find someone who says, hey, I'm actually in the Chapter 13 and I'm trying to refinance my mortgage. I've got a loan officer says that I can and they can reduce my interest rate, but I can't without the court's permission. You do I think I've only seen this once in about 10 years that I've been at the help desk to purchase a home. Someone who says, hey, I've been paying rent of $1,200 a month. I've actually been presented with the opportunity to buy a home where my mortgage payment on a fixed interest rate will only be $900 a month with taxes and insurance. Obviously a much better situation. I'd like to proceed on that. And I've already got someone willing to lend me the money. And I've either got the down payment from savings or a family member or friend is gonna, gift me the money for the down payment.
This is another example, a little bit of an aside, but it's an example of trying just to reduce the angst of anybody out there who doesn't practice 13s and is perhaps just doing perhaps non-bankruptcy or just Chapter 11s. You might be looking at this slide thinking, okay, wait a minute. Section 364 has no applicability to Chapter 13, how am I going to do this? I mean, how is this applicable to somebody in Chapter 13 wanting to get the extension of credit? There is a way to piece together the Chapter 13 code through references in that. If you look at this slide later on and somebody comes in and asks for you to file one of these motions or draft one of these motions or help with one of these motions, there is a basis for it, and the folks at the help desk can explain it to you.
And I will say at this point, I should have added this before, you're not drafting motions from scratch. Legal Aid Chicago has a database of most motions that you will see, boilerplate to start you off with to provide to debtors. So you're not explaining to a debtor how to draft a motion from scratch. They'll give you the notice of motion. There's even just a general one. If one of the long list of motions that Legal Aid Chicago provides doesn't cover what the debtor's asking for. So they'll provide you with the notice of motion, the motion itself, and then the proposed order as well that can be filled in. Most of the most common ones, like modifying the plan, it's just basically fill in the blanks. So don't be overwhelmed by thinking that you're going to have to provide, draft a 5-page motion and do research on these sections. Most of them are form and you're just filling in the blanks. And the last one, approval loan modification. I put that in quotation marks because I'm of the mindset, I don't know if Judge Clear agrees with me or not, that most loan modifications, as long as they're beneficial to the debtor and don't actually change the terms much or actually maybe reduce the interest rate, don't necessarily need court approval. And half the time, the mortgage bank won't bring it up, and half the time they say we do need the order from the Chapter 13 court approving it. I'm of the mindset that if the bank doesn't ask for it and the debtor gets it approved, so be it. If the bank asks for it and you disagree with the bank, good luck making that argument. Just help the debtor file the motion to get the loan modification approved if it's something that they want and will be beneficial for them.
I think that's the exact point because every judge has their own view. Obviously, I can tell you, I don't think it's any secret. I have a view that you do not need approval for the loan modification. However, having said that, the reason I bring it up is to your point. If you have a bank who wants that in order to get the loan extended and the debtor needs it, more likely than not, and I enter those orders because it's to the benefit of the debtor, barring any other circumstances or objection, obviously.
Yeah, and they're comfort orders. The creditor is maybe not 100% certain that they don't require it, so they just want it to the comfort to say that they did, so that creditors rarely, especially big banks, they're very wary of violating bankruptcy, the automatic stay and the discharge. So if they're asking for a comfort order and it benefits the debtor, there's no reason to send the debtor back to argue with a customer service representative at Bank of America. They're going to get nowhere. Just go ahead and help them file the motion to get the loan modification approved. And I think in most circumstances, most of the judges in North District, all of them, unless they're, something crazy like the interest rates being increased from 5% to 17%, are going to approve a loan modification because most of them are beneficial to debtors. All right. So the procedure for incurring post-petition credit, notice in motion, everything that's going to be changed post-confirmation usually requires, other than amending the petition schedules, notice in motion and a proposed order. 14 days notice, but may request a shortened period if it's going to prevent irreparable harm to the estate. And the example I come up with is if the debtor needs to buy a car because they have to drive to work and they aren't going to be able to make it work tomorrow if they don't have this car ready to go. So that's sort of the circumstance that I've seen come up where we've asked for the 14-day notice to be shortened. You must provide, I can't emphasize this enough, you have, in order for the judge to be able to approve it, they have to see what exactly is being asked for. So debtor must provide the credit agreement, the proposed credit that they're trying to take out to the court with material terms, interest rate, payment amount, what is actually being paid, costs. And most of the time, you're going to see this for cars, honestly. Most car lenders that provide it are just going to provide the disclosure for the financing agreement, and that contains all of the relative terms. You will say debtors sometimes say, oh, the dealership won't give it to me because they think I'm shopping around. And I just say, well, you're not going to get this permission, so just find another dealership. I'm not going to recommend, or not recommend anyone, but I will say that there are a lot of national car sale companies, dealerships that market themselves to be out to be bankruptcy. That may be a good starting point for debtors. I'm not saying that they're good or not good, but just most bigger dealerships, I think, understand, have seen the situation before, so they'll provide the document for the debtor to be able to go ahead and hit the order. As with all other motions, you pick a hearing date, pull up the judge's calendar, provide the proposed order, and inform the debtor to be present virtually and be ready to explain their circumstances in a concise 30-minute segment. You may need to combine it with a motion to modify the plan. If the increased car payment, for example, if it's a motion to incur credit, will require the debtor to pay more than they were paying before, that money is going to have to come from somewhere. So you may have to file an amended INJ along with the motion to modify the plan and ask the court to potentially reduce the percentage to unsecured creditors so that the debtor has enough. And the argument there is, without this car, the debtor doesn't work, no creditors get anything, right? The unsecured creditors get 0%. So in this case, it would be, hey, under my original plan, the unsecured creditors were going to get 20%. I'm reducing my plan payment so that I can afford this reasonable car, not a 2020 Ferrari, right? A 2015 Honda Accord that runs and comes with a warranty will require me to reduce my unsecured payment to unsecured creditors from 20 to 16% or 14%. I think that's a reasonable argument, but it does have to come with a motion to modify the plan. Okay. So conversion, so Janeni, I think we're about the halfway point. Have any questions come up?
No questions yet.
Okay. Don't be shy, folks. If you do have questions, I know I'm not doing that good of a job. So if
hey,
questions
Sal,
come,
I can actually intervene because I got a couple of questions that just came to me only, and I answered them. But for the sake of anyone else who might be interested, one question was with the CARES Act extension of 5 to 7 years. Is it 5 to 7 years from the filing or from confirmation? That was one question I got.
From filing, it always operates whether you'll hear mostly talk about the commitment time period of 3 years or 5 years, or in this case, if we can extend up to 7 years, it's from filing, all of those dates. And that's a good point. Debtors should be advised that their first payment isn't due when their plan is confirmed. Their first payment is due 30 days after the case is filed.
Actually, I guess that was the only one. Thanks.
Okay, right, no problem. So, conversion versus dismissal. If you have a debtor in a confirmed plan and they come to the situation that they can no longer make the payment, and they're considering converting their case to a Chapter 7 or dismissing the Chapter 13, it's sort of across. Sometimes the debtor will come in and say, I need to convert my case to Chapter 7. It's always a good question to ask why, to figure out whether that's the best outcome or strategic step to take next, because sometimes it is better to dismiss the case instead of convert to 7, or they may not qualify for a Chapter 7 for other reasons. So you ask the debtor why they're at the crossroad and then what it is that they're trying to accomplish. Some examples, converting or some explanation about converting a case from Chapter 13 to Chapter 7. It's not by motion, it's as of right, assuming that they qualify for Chapter 7 otherwise, and it's usually above median debtors that can't pass the means test, that may not that they won't qualify, but that they have a presumption of abuse that they would have to overcome in the Chapter 7. But assuming that they qualify otherwise, it's as of right, so they just file a notice. It's not a motion, it's just a notice that they've converting their case to from Chapter 13 to Chapter 7. They provide notice to the creditors. The debtor may add post-petition debts. This is a beautiful section of the code that allows, of bankruptcy I should say, that allows the debtor, if they file the Chapter 13 and any new debts have been accumulated in the year or two or whatever time period that they've been in, they can now add those debts to be discharged in a Chapter 7, assuming they qualify to be discharged otherwise. There is a new Chapter 7 trustee that will be assigned to the case, which means that there is another creditors meeting under Section 341 that will be assigned. So just inform the debtor that if they do convert, that they'll have to attend another creditors meeting. The 8-year wait, this comes up a lot. The 8-year waiting period still applies. If they had the 2468 rule, as it's called. If you file the 7, you cannot file another, from filing date to filing date, you cannot file another Chapter 7 for 8 years. If you file a 13 and now are trying to file a 7, you have to wait 6 years. If it's 7 to 13, it's 4 years, and 13 to 13, it's 2 years. So if the debtor filed their Chapter 13 5 years after having filed the Chapter 7, and they've been in the Chapter 13 for 2 years now, they say, oh, great, now I'm past the deadline, the waiting period, I should say. It's been over 8 years. Now I can convert to a 7. It's like, well, no, your original filing date is what controls, not the conversion date. Now, in that case, they would be able to dismiss and then just file Chapter 7 because the new filing date of the Chapter 7 is what would count. So pros and cons of converting a case to Chapter 7 versus dismissing to Chapter 13. You don't have to redo all the petition and schedules, right? You just add any additional creditors that were post-petition, post-confirmation. You don't have to retake credit counseling. Only debts that, some of the cons, only debts as of the conversion date will be discharged. So if the debtor, the reason that the debtor is looking to convert is I've lost my job and I have no income, like, well, then maybe you should consider, you haven't seen the light at the end of the tunnel. How long is it going to take you to get income again and sort of get back up on your feet? If it's another year or two, you're more than likely to accumulate more debts during that time. Heaven forbid you fall down the stairs tomorrow and you're in the hospital and you've got no income and no health insurance, you're likely going to have some medical debts tied to that incident. So advise creditors to think about it, whether it's the best time for them to file, or whether they're better off dismissing or just dismissing and waiting to file 7 down the line. And then another con, 8-year waiting period, like we said.
This topic is actually, just a little bit of a side, is the reason that I'm involved in this program. When we first started marking up the various segments that we've had, this now being the 4th, I mentioned I thought that when I was sitting at the help desk, this was always a very confusing area for me. Confusing in the sense is I wanted to make sure that I got it right for the debtor. And there's a lot of strategic thinking that you just heard Saul go through, that if many of you who don't do this every day might think, how am I gonna properly give the advice on what to do here? But that's why we're having this session. That's why we have the handout. And that's why Saul mentioned, and I mentioned, go to the resources, at the help desk in LAF. Ask the question, and that's a great start. That's a great part of you accomplishing your job. Ask the question, find out, what's going on here, why are you doing this? And once you identify that, you don't have to make a split, second decision. Go do the due diligence and ask somebody, because it is complicated in a sense, and it deserves a little bit more attention than just a split section reaction and a decision. And you don't have to do it. So don't be frightened about getting those questions. Don't be frightened about taking on clients to say I have this type of issue. Just know that you're doing a good job identifying it and then going and get the help.
And not only, I mentioned earlier that there's help before, right? You're giving the information ahead of time to do your research, but it is perfectly acceptable to tell a debtor, I'm not 100% sure here. Let me get back to you with that answer. Give me a day or two. And the help desk has an email. And if you wanted to, you can always call them back, or you can send an email from the help desk, or you can send the words, the verbiage of that you want to send to Jadeni, and she'll email it from the help desk email. So it's always an acceptable answer. I mean, sometimes in our own practice as a client, we'll have to tell them, I'm not sure, I have to research that to get you a more concrete answer. That's also perfectly acceptable here at the help desk, to say, someone, I don't want to tell you that will give you the wrong information. Let me look into this a little bit further and we'll follow up with you. That's perfectly acceptable. So 13 to 7 conversion procedure, you file the notice of conversion. There is a filing fee difference between a 13 and a 7. A 7 is more expensive, so you have to pay the debtor has to pay the additional $25 in filing fee, unless they had a waiver of the filing fee. You file an amended DEF to add any new debts if there are any, and there is a $32 fee for that. Chapter 7 requires a statement of intention for any secured debts or leases, and that's just the debtor telling the court what they intend to do with that secured property. Not required in the 13, but it is in the 7, so that has to be filed. And they have to plan to attend the new 341 creditors meeting. So now, voluntary dismissal instead of converting a case in Chapter 7. So first I'll say, if the debtor takes no other action, stops making payments, the trustee is likely to file a motion to dismiss, and the case is going to get dismissed anyway. I never recommend that. I tell debtors, once a case is involuntarily dismissed, you lose some rights. So it's better to file a motion, ask the court to voluntarily dismiss your Chapter 13, give a brief explanation. As long as you're not trying to avoid something inappropriate by the dismissal, the court's going to grant it. So if the case if the case is dismissable, right? If you were in a Chapter 7 and you convert it to a Chapter 13 because the Chapter 7 trustee found out that you had a $15,000 bank account that you were trying to hide, or $40,000 of equity in your house, and you converted it to a 13 in order to not have your house liquidated, then you can't escape that by filing a 13 and voluntarily dismissing the 13. The Chapter 13 trustee is going to object to that, and the court's going to say, we can't dismiss you here because you either have to convert back and have your house liquidated or figure something else out. So it must be by motion. It's not as of right. So some of the pros and cons to voluntary dismissal over conversion. A pro, you save the discharge, right? Like in the example, if someone has lost their job and doesn't know how long they're going to be out of a job, and that's why they're looking to convert. So like, well, save your discharge. If you convert to a Chapter 7 and you have your assets, you have your debts discharged right now, and then you do fall down the stairs next week and you're in the hospital, you're going to be stuck with those bills for 8 years, right? You can't file another Chapter 7 if you're going to be unemployed for a long period of time. So you save the discharge. Bankruptcy is a very powerful tool. It's that sledgehammer in your tool of rights if you're a debtor, and you only save the sledgehammer for the big jobs, is the way that I explained it.
All right, we have a couple of questions relevant to, it looks like, dismissals. So we have someone who quickly asked, what rights does the debtor lose when it's involuntarily dismissed?
So the most common is if you've had a case involuntarily dismissed in the past year and you file another case, your automatic stay, the protection that you get when you file a bankruptcy case, is only in place for 30 days. And you have to file a motion inside of those 30 days asking the court to extend the automatic stay. If you've had 2 or more cases involuntarily dismissed in the past year, then you have no automatic stay when you file that 3rd case, and you have to file a motion immediately after asking the court to impose the automatic stay and explain what's different this time. This comes up a lot because pro se debtors, sometimes before they come to the help desk, may file the example I gave earlier, that they'll file a bare bones and then just lose track of the 14 days and have their case dismissed. And the next thing you know, they come to see you and they've already had 2 or 3 dismissals. And now not only are they facing the issue of not having the automatic stay, but now the court may see them as a serial filer, because when you file a bankruptcy case, the court docket automatically auto-populates how many cases they filed in the past and the dates of those filings. So it just doesn't look good, first of all, but there's also some statutory issues when there's involuntary dismissals that they lose rights. They have to ask the court to impose those.
And I'll just add, as long as we touched upon it, I'm sure that the motions to extend the stay, which Sal's sort of referring to tangentially here, came up in one of the earlier sessions. But yeah, you lose your stay if you're a serial filer, as Saul mentioned, if you've had a case involuntarily dismissed within a certain period of time. And you have to be aware of that because the court only has a prescribed amount of time in which to grant the motion extending the automatic stay, or it's lost forever. You have to have that motion to extend the automatic stay after you file that next case within 30 days, and the hearing has to be done. So I was going to bring it up earlier and I didn't. I don't certainly want to volunteer any of my other colleagues or take a position for them, but from my perspective, if you get one of those debtors who come to you, their case was involuntarily dismissed, as we're talking about now. They waited because they just didn't know what to do, or obviously these debtors have other things to do, but now they're showing up at your doorstep saying, I need to, I filed another case, a bare bones one, and my stay might get extended, or they show up and you realize their stay might not get extended unless they file something very quickly. And you look to the docket, as Saul was mentioning before, to find out when we're sitting. We're on a little bit of a limited basis now. We've altered our schedules, the judges have, as far as when we'll hear hearings. And if I'm hearing a hearing only on a certain Monday and I have a Monday off, and therefore you need to get in to have that stay extended within the next 7 days, but I'm not sitting for 14, file an emergency motion. The stay is very important for these folks, and it's not, it's not something you did, but you're presented with the issue and you see that they have to have that stay extended, file an emergency motion and try to get it heard before that stay extended, because once it's gone, after they file their second case, you can't get it back.
Yeah. So just like I said, a few things to keep in mind when making this decision. This is, as Judge Cleary said, one of the more complicated strategy decisions that comes up. If you're not sure and you want to chat about it, I'll say for myself and most of the longtime help desk volunteers, we're all willing to take 10, 15 minutes to chat with you about a case. Dan as well, the attorneys at LAF. No one's ever going to leave you stranded. If you really do need to talk about something, one of us will be willing to sit down with you and go over it. I get phone calls and emails from actually Legal Aid and CBLS, who runs the helpline for Chapter 7s with attorneys with questions. I mean, it's 5 minutes out of my day usually where we can, and most of the time it's confirming their instincts, because once you do a few of these, your instincts tend to be correct. You're just kind of looking for that, hey, I'm not missing anything here. And most of the time it is the case. So time bar discharge, I talked about this earlier. Someone may be in a 13 because they weren't eligible for a discharge in a Chapter 7. And now that they're considering a discharge versus dismissal, it's like, well, you can't convert, because if you convert, the original filing deadline applies. So voluntarily dismiss your case. Don't let it be involuntarily dismissed, because then you're going to have the issue with the 30-day automatic stay. Have it dismissed and then file your 7, and the bar no longer applies if you're past the 8 years or the 6 years. Some of the cons, you lose your automatic stay. And also an important one, any cram down. If you have a secured creditor like a car that, from Yannick's presentation last week, wasn't a 9-10 day car, meaning that they have had it for longer than 910 days when they filed the case, the debtor is allowed to pay the value of the car versus what the contract term is. If you voluntarily dismiss the case and the debtor's 3 years into it, all the original terms revert, and now the debtor is going to be severely behind on their car note payments. So that's something that should take into consideration. I mean, the same issue would come up in a Chapter 7 if they convert, but in that case, then they might be able to do what's called a redemption, which is similar, but a little bit more difficult in certain aspects, because they have to pay all of it upfront instead of overpayment. But if you come up with that issue, just and you're not sure, just call Legal Aid Chicago or one of the help desk volunteers, and we're happy to chat with you about it. Dismissal procedure and notice in motion, like we said, you pick a hearing date, same as before. You provide, I'm going to start to go a little bit faster because I think we're running to about 10 minutes left. Provide a proposed order and inform the debtor to be ready to present their case concisely and to practice it in 30 seconds. So what happens upon completion of payments and granting of a discharge? It's actually simple, more simple than people expect, right? There's certain things required for discharge. You complete the plan payments. Then you have to ensure that the creditors, the general unsecured creditors, receive whatever minimum percentage they were required to under the plan. It's usually simple enough. You pull up the plan and you actually see how much they've received. And if they have, then the debtors has finished. Sometimes they may be short. The plan may require that they receive 10%. And then when you run the numbers, you see that they've only received 9% and there's $200 short, in which case you have to tell the debtor that they have to either modify the plan or come up with that extra $200. Most of the time, though, when the debtors have made it this far, 3 years or 5 years, and they've completed their plans, then they've met all the minimum requirements. There's a second course. They call it, it's not credit counseling, it's called debtor education, but the simplest term, the term that I always try to use with creditors, with debtors, is the first course and the second course. Because if you use credit counseling versus debtor education, it leads to a lot of confusion. You just first course, second course. The second course can be completed anytime after the case is filed. You don't have to wait until after the 341 meeting or after the plan payments, but just make sure that at the time that debtors completed their plan payments, that they have completed the second course. If not, they should do it as soon as possible. It does take a little bit longer than the initial course.
But you can't overemphasize that, Saul. I mean, I think best practices is to recommend that they do that immediately after filing the case. So often it just goes by the wayside, and if nothing more, they have to reopen the case if they didn't do it, and they have to make another payment of a certain amount of money. So do it right away so you can get your case done.
Yes, absolutely. And it is, in one of these slides, you'll see that is probably the most common problem that we see at the help desk. A debtor coming in and they did not get their discharge because either they didn't complete the second course or they didn't file 423. So just emphasize the debtor to do that right away so they can get it out of the way, because these plans are 3 years and 5 years. Sometimes debtors forget. So within 30 days, another thing that the debtor doesn't have to do this, but if they have a mortgage, they should be on the look out for this, that the trustee will send a notice of completion of plan payments. That is very important, because if the debtor has made all of their, or thinks that they have made all of their post-petition mortgage payments to the mortgage bank, right, and the creditor, the mortgage bank, does not object to this within 21 days, They cannot, attempting to say that the debtor was behind during the plan later will be a discharge violation. So that's just something to tell debtors to be on the lookout for, that if they are behind, the bank's likely to file an objection. Completing debtor education course, it's simple. There's an approved list on the trustee site. They must file, the first course, credit counseling, they file the actual certificate. The second course, debtor education, they don't file the certificate. The certificates look exactly alike, except one says credit counseling and the other says debtor education. For the second course, they have to file Form 423, which is just a certification that they completed. And in that certification, they put in the certificate number, the date and time that they completed, and what company they completed it with. Failure to file Form 423 means no discharge. This is one of the most common issues that we see at the help desk. Someone who will come in both for 7s and 13s, sometimes years later, saying, I'm getting a call from this creditor trying to collect this debt, but I had this discharge and I had my bankruptcy and they're telling me I don't have a discharge. It's more than likely this. They can cure, but there is a $235 reopening fee, $260 in Chapter 7. More about that in a second. As we said, it's one of the most common issues. Sometimes it can be a blessing in disguise. I've had debtors who come in 5 years after their case was closed without a discharge, and they're saying that they've got a creditor coming after them for a debt that existed pre-bankruptcy. You can tell them, we can obviously advise them to reopen their case and file Form 423 so that the discharge will be automatically issued. But ask a few more questions, right? What is the current situation? Remember, there's that 8-year bar. So if they are at the issue where they maybe are starting to be contacted by debt collectors and creditors at this point, and they may benefit from a bankruptcy now. So something like, you may want to consider filing a new Chapter 7, which would discharge the old debt, and you're not facing the time bar because of the prior discharge. Just something to keep in mind. The debtor certification regarding domestic support obligations, or DSO as it's most commonly called. Just basically, the debtor was not required to pay a family support obligation, or is required to pay and was current as the time of the completion of plan payments. It's a simple form, find on the Bankruptcy Court's website. Nothing else is needed. Form 423, DSO, no final hearing. The discharge is automatically issued by the court system. The debtor and the creditors are mailed a copy of it, and there's a copy of it you can download a copy of it from ECF as well if the debtor, once it comes to see you, needs a copy of it. Case is closed usually a few days after the discharge is issued. So hardship discharge, probably going to come up a lot more often now with the situation of COVID. The court may grant there's 3 requirements where a court may grant a hardship discharge. And essentially, a debtor has attempted in good faith to pay, for one reason or another can't continue and needs a Chapter 13 discharge. The debtor's failure to complete plan payments is basically no fault of their own, nothing that they should be held accountable for. The second part, the simplest way to explain it, is the best interest of the creditors test, the liquidation test. If the creditors would have received more if the debtor's assets were liquidated in a Chapter 7, right? If the debtor has $40,000 of equity in their home, and if they had filed a Chapter 7, they would have had to pay $20,000 of that. And in the Chapter 13, they've only paid $18,000, then they cannot qualify for a hardship discharge, right? Because the creditors are being shorted $2,000. So that's the simplest way to explain it. And finally, 1329, modification of the plan is not practicable, right? It's not, hey, I'm making less money now, so I can't afford the plan payment anymore. It's like, well, can you afford if it were reduced? And would it be a feasible plan if it were reduced? So it does come up. I've done it only a handful of times because it's only usually the most extreme circumstances where it's required, but some things to keep in mind. It must be done by motion. If granted, you must still comply with the other requirements of domestic support obligation and the debtor education for Form 23. Importantly, hardship discharge will not affect secured creditors or priority creditor claims. If you were receiving a cram down on a car and that car has not been paid what they were required to in a cram down, the discharge will not allow the debtor to keep the car. Also, if a priority debt has to be paid in full, it's just something else to keep in mind. So just bear in mind that hardship discharge comes with some restrictions that will kind of pull what the debtor was trying to accomplish back.
And you are right, Sal. I mean, it's a useful tool, but it's a very difficult tool in some respects to satisfy all those. Won't go into all the reasons why you can and cannot do it, but just add there's another twist that people will need to think about, because the good and the bad of the CARES Act, on the one hand, if you qualify, it could allow you to extend up to 7 years. Therefore, if you extend up to 7 years, you might be faced with an objection that you should be using that provision rather than it is practical. It's not satisfying the hardship discharge by being impractical.
And honestly, most clients who come in seeking a hardship discharge wind up being better served by a conversion, unless they don't qualify for other reasons. So just bear in mind, sometimes someone with I heard that I can qualify for a hardship discharge. My friend, my cousin, so-and-so got a hardship discharge. Yeah, find out why. Most of the times they'll be better served usually by a conversion to a Chapter 7. But in the case that it does come up, just bear in mind that there are some restrictions to it. So, so discharge violations. So I think we're at 5 o'clock, so I'm going to go through these quickly because we see less of these last few items. There's a prohibition on discrimination by government agencies, private employers, or student loan lenders. Violations of Section 524 may be punished by contempt of court, actual damages, attorney's fees. So I add this because if someone comes in with a discharge violation and you confirm that with them that it sounds like a discharge violation, there's plenty of private attorneys that will do these cases because there's attorney's fees and court costs that are provided. So there's no reason for the debtor, unless they, for whatever reason they want to come up with, they have every right to represent themselves. But usually when you tell them that this violation comes with attorney's fees and court costs and they can get an attorney to get paid from the creditor, most of them are happy to do so. And we obviously don't poach clients from the help desk. I have never taken a client from the help desk, but we do refer to Legal Aid Chicago or to one of the organizations like the Chicago Bar Association or Referral Line, or the National Association of Consumer Advocates, or the National Association of Consumer Bankruptcy Attorneys, where there's a list of all sorts of private attorneys that the debtor can find and call around and see who they feel comfortable with. So I just mentioned that if it is something that sounds like a discharge violation, there's some steps that have to be taken. Is sending warning shots usually is the way that it is explained. If you just file the discharge violation without giving the creditor an opportunity to correct it, a lot of times the court won't be willing to provide sanctions or attorney's fees. So I always advise debtors that even if they're proceeding on their own, they're better off by sending a quick letter or faxing or even an email advising the creditor. And then if the creditor continues, then probably seek counsel. So in re Mendiola, the easiest way to explain it, if the debtor inadvertently omitted a creditor on a filed schedule and it was a no asset case in a Chapter 7, then omitted creditors, debt is still discharged and the debtor is not required to reopen the case to amend. It's a little bit more complicated in a Chapter 13 because obviously if the debtor omitted a creditor on their Chapter 13 and the unsecured creditors received some portion of funds, then this creditor was prejudiced because they did not receive whatever portion they would have received, so they're likely not discharged. So in re Mendiola comes a lot more often with Chapter 7s and Chapter 13s. Yeah, that's the entire presentation. Questions? Only 2 minutes over.
Okay, so we did have one question a little further back, and someone was asking, how would you advise clients who have fallen behind on their plan payments?
So I think going back to the screen on steps to be taken when a client comes in wanting to modify a plan, right? Ask what it is that, first review the confirmed plan and then find out what it is that they're trying to accomplish, right? If they've had reduced income or they've fallen behind because they have no income, I mean, there isn't much that can be advised. You go through the options of, well, you're maybe laid off of work for 3 months and you're going to restart work in April. So I'm like, okay, then you can control, you're going to restart making payments, potentially extending under the CARES Act up to 7 years, adding another 6 months at the end of the plan. If the unsecured creditors were receiving 50%, there's an opportunity for reduction. The creditors do that. Or if they've only fallen behind, my car blew a tire and I had the tire replaced, so I missed 2 payments, but I have the ability to continue to pay and there's no room to decrease the percentage to the unsecured creditors, they just have them file a motion to defer to default to the end. They've got plenty of time to make it up, and just tell them that they're going to have to find a little bit of extra money here and there to make up that $200 or whatever, $400 over the life of the plan. It's situation dependent.
Great.
as is often the case. I think that's all. There weren't any other questions that I saw. You guys were so good that we lost no participants whatsoever after the 5 o'clock hour. Everybody wanted to stay right to the end. Thank you so much, Sal and Judge Cleary, for doing such a great job with this and bringing us home. And for all of you participating, thank you. And all the CLE information you need is in the chat. And we hope very much that some of you will consider giving us a try. If so, you can contact Legal Aid Chicago directly on our website. You can contact Yadeni. You can contact me. If you forget or can't find our contact information, you can get it from Sal or Judge Cleary or probably any of the other judges. So hopefully you'll find your way to some of you will find your way to us, and you can join us in this really satisfying work. And thank you again.
I'll just end by saying, if you're thinking about it, do it. If you decide that it's not for you after shadowing a few times, no harm, no foul. But I promise you, you will find it rewarding and you will enjoy it.
Thanks so much. We did have a final question here. Are there recordings of the prior Zooms? So the answer is yes. We accidentally did not record the first one. We have the second, third, and fourth ones. So
convenient, the one that you did, Dan.
Yeah, the one that Danny and I did. You don't need that one. That wasn't so good. We will figure out. So Denny, can you just put your email again, like in the chat, and then the person who's asking this question can get your email and get in touch with you, and we can work on that if they want to. Okay. Great. So I'll people are free to go. I'll leave this open just so Denny can get her email in the chat. But thanks again.
Thank you all.
There it is. For whoever's still here, we've got Denny is just Jay Cortez at legalaidchicago.org. And Sal, we'll be sending you a bill. It's a quarter for every time you said LAF.
Yeah, I'm probably going to be up into the thousands at this point. I have it's hard. It's a long time to
No worries.
First, I had to get used to LAF. Right, we were legal assistance foundation, and we went to LAF. I finally got used to it. And you guys changed it up on me again.
That's right. Well, we still all do that. I'm going to
end the bill.
End the recording here. We're still